Hello, everybody, and I'm Gianclaudio Malgieri. I'm an associate professor of law and technology at Leiden University, and I'm extremely happy and honored to present my new paper about scalable fairness, a legal tool against power, at ACM FAccT Conference 2025. The subtitle of my paper is indeed Legal Tool Against Power, and why? So the starting point that I want to focus on is the strong link that especially in the digital world we observe between human vulnerability, in particular as theorized by scholars like Marta Feynman, and needs and dependency is extremely visible here. So, for example, if we look at to understand vulnerability of a certain person that here we can call A, we need to understand that vulnerability is rooted on their needs, physical, psychological, or social needs. In addition, those needs can be satisfied by society, by others, by different entities and institutions. But what if some entities that here we call B are in a position to satisfy my needs in a quasi-exclusive way, so in a monopolistic way? This is the case for big tech. This has been the case for a lot of time. So going on this analysis, we can say that if there is a quasi-exclusivity in satisfying my needs, there is a dependency from me on B, and B is this new entity that might be, for example, big techs, and so a great possibility of B to harm the powerless person. So why this? Why is this important? It is important because the amount of power imbalance and dependence and vulnerability is an imperative towards powerful entities, and so towards the state to regulate powerful entities in a way either to reduce power imbalance or to make sure that the power imbalance and dependency does not create a great possibility of harm. So in order to reduce the possibility of harm, there is a tool that is wherever in the legislation and has been there for centuries, but now is even more and more present, and is the concept of fairness. So fairness is a principle, a legal and ethical principle that is present in many laws and can be really the tool to avoid that great dependencies can turn into great harms. And I will be more specific soon, but just let me say that this is the continuation of a previous paper that I had the opportunity to publish again at FAccT conference 5 years ago, again when FAccT conference was held in Europe, and where I had the opportunity to analyze the concept of fairness in data protection law, so in the general data protection regulation, and I made a linguistic comparison in order to show that fairness is not just a procedural concept, but is a strong, substantial concept. So it's about substantive fairness. And why do we say that? Because if we go back to that paper, I made a table in which I tried to compare different forms of linguistic interpretations of the concept of fairness, which is still something done, and which is still something that is admissible by the Court of Justice of the European Union, where we know that the translations can help to add more nuances. And from that comparison, we can see that the concept of fairness refers to many different concepts, but all of them are substantive, or most of them are substantial. For example, in German, fairness means treu und Glaube, which means good faith, contractual good faith. But also in other languages like French, Spanish, and Portuguese, it refers both to loyalty, which is connected also to trust, and to equity, which is extremely substantial. So fairness is substance, and we see this not just in respecting user expectations, but even to, proportionally to the power, be able to understand how to mitigate risks for the counterparty. So in data protection, we had several cases of enforcement in the last years where we saw that fairness is really a scalable concept. For example, in the Court of Justice of the European Union, Bundeskartellamt case, the court has said that the great market concentration of Facebook impose higher duties when we want to collect consent. So the story is that the bigger the power imbalance, the bigger the market concentration, the higher the standards for lawfulness and fairness. Also, in many data protection authorities enforcement cases, for example, the Irish case or the Italian case, fairness was usually used to as a passepartout against substantive violation of interest and expectations. So, my concept of scalable fairness starts from an assumption. Fairness has been there in the last 2 centuries as a legal concept in different domains and in different ethical analysis. We have at least 5 layers of fairness. We have the indifference fairness, which is the fairness that we should give when there is no power imbalance between me and the counterparty. And it's the roles concept of do no harm. But then, if our power began to increase, for example, there's a peer-to-peer contractual relationship, then we have good faith, Trojan love, a good faith fairness. And then the bigger we go, so the higher we go with the power imbalance, for example, consumers versus businesses, then fairness means more. For example, fiduciary fairness, to avoid manipulation, to avoid discrimination. But then if we are in a situation of big power imbalance, for example, users against the big techs, then it's not necessary to just avoid deception and avoid manipulation. We should do more. Power imbalance in this case would impose to proactively protect fundamental rights. For example, we have risk assessments in the AI Act, we have risk assessments in the Digital Services Act for very large online platforms. And then we have the maximum imbalance, which is the maximum dependence when we depend on states. Of course, this depends on the social, historical, political, and economical situation. But that fairness is even referring to social justice, so to actively enforce fundamental rights. So this is just to share that fairness should be proportional to the power imbalance. Fairness is there, is in every relationship, is in the relationship with another pedestrian on the street, is in the relationship when with someone we want to have a basic peer-to-peer contract. But then the bigger is the imbalance, for example, business and big techs or even the state, the more fairness means something. So, just to conclude, today big tech are quasi-sovereigns. They are gatekeepers of our rights, also of our rights of autonomy, freedom of association, and so on. And that's why I'm claiming that that they should have an empathy fairness, so fairness towards plus anticipatory governance. We should align with ethical design, impact assessment, and dignity-oriented governance. Empathy, in this case, means more than just avoid manipulation or avoid deception, but it means trying to use compassion towards the counterparty, so towards the digital user. So fairness is a scalable concept that should expand proportional to the digital power imbalance. Thank you so much for your listening, and I'm very happy to hear if there's any comments or questions even in future iterations. Thank you very much.